And now we are back together as I pull up our schedule for panel 4, Inheritance, Rights, and Wrongs. The discussant for our panel is Richard Roberts of Stanford University. The papers that will be discussed on this panel are Challenges, Coping Strategies, and Consequences of Bereavement for Middle-Aged Widows and Widowers in Effutu Municipality, Central Region, Ghana, by Pearl Hammond of the University of Cape Coast. We also have Upstanding Veuves, Redefining Women's Public Status in Post-Emancipation Gorée, the author of which is Sarah Zimmerman of Western Washington University. That will be followed by Resisting and Owning, Widowhood Fatwas in 19th and early 20th century Mauritania by Abbass Braham of Louisiana. I'm sorry, I don't have your affiliation properly noted here, Abbass.
Yeah, University of Louisiana.
University of Louisiana. Congratulations on your wonderful job. The last paper will be The Social Context of Widowhood Rights and Women's Human Rights in Cameroon by Mathias Fubah Alubafi of Pretoria. And with that, I will hand things over to Richard Roberts.
Thank you, Emily, and thank you, Benjamin, for organizing this, and thank you all for participating. So this panel provides for a range of different methodologies into the question of widows and their experiences. We have in Mathias's paper an example of ethnographic fieldwork from the Cameroon grasslands. We have in Pearl's presentation evidence derived from a large N questionnaire and a smaller set of qualitative interviews from widows and widowers in the central region of Ghana. We have in Sarah's paper an example of historical research into the presence of widows on the island of Gorée. And we have with Abbass's paper an example of closely analyzed Islamic legal documents from the 19th and 20th century Mauritania. All these different research methodologies yield insight that widows and widowhood has been and continues to be a viable social category of analysis. The study of widows and widowhood thus provides insights into the inner workings and inner contradictions of contemporary and historical societies. That said, these papers and their different methodologies also make clear that the social categories of widows and widowhood lumps too much together, and we need to disaggregate these different variables. Widowhood is at once emancipatory, yet also confining. It sometimes opens new options for social life, yet it also introduces new forms of precarity. In particular, widowhood exacerbates gendered social vulnerabilities of women, particularly in regard to access to land and labor, control over property, the authority of their own consent in life choices, including subsequent marriages, and especially control over a widow's children. The other important point to make at the outset is that widowhood is an unstable category, which means that the experience of widowhood must be situated within a wider set of changes affecting the community. Following Jane Dyer, the social experience of widowhood is a dependent variable determined not by age-old customs, but by changes in the political economy of power and how power is instituted and challenged. So let me begin by unpacking several aspects of widowhood. And to do so, I have 7 variables for us to consider. The first is the wider and changing context of wealth and power. Widowhood has been largely shaped by changes in wealth and how the changing nature of wealth and power are clearly co-determinative. Wealth and power are rarely equally distributed in society. Even in societies that are relatively poor, social hierarchies translate into unequal access to resources. This has implications for widows. Widows with access to wealth and property have wider circles of choice in their future lives than widows who are relatively poor. However, wealthy households do not always confer wealth to widows. Wealthy households also tend to have, where it's permissible and where it's socially sanctioned, polygynous marriages. Not all widows are treated equally. As Paul Lovejoy and Barbara Cooper and others have argued, polygynous households in Muslim regions often incorporated slave women as concubines. We need to be attentive to the internal dynamics of households in order to understand the nature of what constitutes wealth and how members of households compete for access to it. Second, as Benjamin mentioned in the previous session, bridewealth is a foundational practice in much of Africa and has significant implications for the meaning of widowhood. Bridewealth is a practice whereby a groom's family or lineage exchange something of value, could be labor service, commodities, livestock, or cash, for the rights to the bride's labor and reproductive power. We might want to consider this the commodification of rights to a woman's labor and reproductive power. The death of a husband did not extinguish the husband's households and lineage rights to his wife's labor and reproductive power. Bridewealth thus has significant implications for the life choices widows can make. And it has, first, it confines, bridewealth has significant implications. First, bridewealth confers the children to the husband's kin. Second, many African societies practice levirate, whereby widows are inherited together with other forms of wealth by the heir to the deceased husband. And widows sometimes have the option of seeking other husbands, and thus be released from the initial transactions of bridewealth, but only if the new husband reimburses bridewealth to the deceased family's kin. Bridewealth, as transactions in the rights of a woman's labor and reproductive power, thus constrains widows' choices. Third, access to land, labor, and property clearly shape the experience of widows. There are at least three aspects to this variable. First, forms of descent and marriage location shape how both wives and widows get access to land and labor. In patrilocal residence systems of marriage, where wives move into their husbands' households, wives' and widows' access to land largely depends upon continued goodwill of their husband's kin. A disobedient widow may face significant risk to losing access to land and labor and thus subsistence. The risks of losing access to land and labor and subsistence clearly shape choices of widows. In many African societies, women have rights to their own property. As Abbass discusses in his paper, there are numerous legal disputes in Mauritania in which widows sought to trace and extract their own wealth from that of their household. This is also the case in Sarah's discussion of widows in Gorée, many of whom inherited significant wealth upon the death of their husbands. Having significant wealth translated into a wider range of choices in widowhood. And finally, we need to be attentive to how how different all these practices are in urban areas. We tend to have fetishized in so many of our discussions rural areas. But as Africa has become so much more urbanized over the course of the 20th century, the experience of widows has changed as the foundations of wealth and kinship have also shifted. But even in urban areas, secure access to property and property rights is a critical aspect of the life choice of widows. The fourth point, the age of widowhood shaped the experience of widows. Age of marriage has been changing over the last century, But the basic characteristic in Africa is a significant differential between the husband's age and wife's age in marriage. This differential was probably less great in first marriages, but ever increasing in polygynous households. Most women, therefore, could expect to be widowed in their lifetimes. For younger women, remarriage was a viable option, even in the face of constraints of bridewealth. Older widows had fewer life choices precisely because remarriage was less likely. Access to wealth and age of widowhood become significant co-determinants of a widow's life choices. Fifth, child custody clearly shaped a widow's choices. As we have already mentioned, Bridewealth transferred rights to children to the husband's kin. Even if a husband's kin did not demand custody of their children immediately upon the death of the husband, they could claim them at any time. Leaving children behind to remarry outside the husband's kin's post posed significant barriers to a widow's life choices. Sixth, Islam and Christianity also shaped the experience of Christianity of widows. These two religions and their many variants in Africa establish principles of normative domestic life. Both religions link domestic life to legal practices. Islam has specific rules and practices regarding the host of issues involving marriage, divorce, and widowhood. Christianity also establishes clear practices that were often enshrined in colonial era legal codes. And any discussion of widowhood needs to be mindful of the influence of Islam and Christianity. And finally, legal changes. The law is never static. And even if religious legal scholars assume that law is God-given, law does change all the time. Law is deeply entwined with wider changes in wealth and power. Law also adopts, if slowly, the changes in prevailing ideas about gender and society. Any discussion about widows and widowhoods should therefore be in close conversation with legal changes about marriage, child custody, inheritance, and property rights. These changes have occurred periodically during the colonial period, again when post-colonial societies rewrote their legal codes, and in response to international human rights conventions. The question here is, how deeply do such formal legal changes influence social practices? With all this in mind, let's turn to the papers. Pearl's paper on coping strategies and consequences of bereavement for middle-aged women in Effutu Municipality touches on several of the broader issues I've raised, including age of widowhood and Christianity. Based on a large quantitative survey and a smaller set of qualitative interviews, the author demonstrates how the power of Christian communities in Effutu Municipality helps widows cope through the trauma of losing their husbands. Most of these widows were middle-aged, which raises the issue about the possibilities of remarriage. The larger agenda of this project is to demonstrate the deleterious effects of widowhood and how, in significant absence of government programs to address the psychic as well as material challenges facing widows, Christian communities have jumped into the void and provided healing and material support. The paper also should begin to examine some of the other aspects, not just the beneficial aspects, but also the constraints that may prevail when Christian communities help widowed congregants. To what extent does such help constrain a widow's life choices, including whether or not to leave these Christian communities after widowhood? Sarah's paper, which is an early glimpse into a larger project on the history of Gorée, provides some fascinating evidence of the unstable category of widows in the period 1750s to 1830. This period is significant not only because of the changes in colonial rule from French to British to back to French during the Napoleonic Wars, but it's also significant because it bridged the transition of slave exports to the trade in bulk commodities. Based largely on preliminary work in the archives, and including household surveys, curial or church records, and a sample of census records, Sarah argues that widows on the tiny island of Gorée were often invisible, in part because they were not identified as widows per se. Sarah critically examines the limits of her archival sources and the challenges of tracking individuals whose names may also have changed. Among her significant findings was that female-headed households constituted 86% of all households surveyed in 1767. Many of these female-headed households may well have been headed by widows, and thus lends significant support to the wider history of the seigneurs in Senegal and West Africa that we've already touched on in these discussions. The seigneurs were often common law wives of European merchants and officials who died at extremely high rates and often left their wealth in the hands of their common law wives. Part of the question about the high level of female-headed households has to do with the ways in which wealth and power were structured in the colonial towns of Gorée and Saint Louis. But we also have to think about how these practices were informed by metropolitan legal norms. Sarah might want to think a little bit about the French and English legal practice of couverture, under which wives were subsumed under the legal identity of their husbands and thus lost control over their wives. Remarriage under couverture may not have been in the interests of wealthy widows. Many of these widows also owned large numbers of slaves, many of which had skills that were in high demand in urban construction and commerce. To compare with Daniel's that we had in the previous section, Daniel's Mozambican Register of Slaves, Owen Westfield has recently argued that the 139 slave owners on Gorée owned 3,900 slaves. So the 139 slave owners owned 3,900 slaves. And many of these major slave owners were the widows Sarah is discussing. Abbass's preliminary paper extracts widow cases from the compendia of Saharan legal documents, often fatwas or legal opinions generated by legal scholars in response to the ambiguities in Muslim law and practice. Much of Abbass's discussion of widows comes from the compilation of Al-Ghasri, and we certainly want to know a little bit more about Al-Ghasri and who he was, when he worked, and where he worked. In selecting widow cases, Abbass demonstrates that widows were directly or indirectly agents in securing their own wealth and well-being following the death of their husbands. Widows' wealth, if she had any, stemmed in part from the dower or mar, which are presents given by the husband to the wife, and also by dowry provided to the wife by the wife's kin at marriage. The dower and dowry are not the same thing, but they provided the wife with wealth that was often commingled with that of the household. Al-Ghasri collected several cases in which the widow sought to trace and extract her wealth from that of her deceased husband. We should also note that Islam prescribes inheritance shares for widows, but not for concubines. Turning to the paper on grasslands region of Cameroon, based on extensive field work, Mathias asked, why do harmful widow practices persist to this day in the face of changing laws, and especially in the face of UN and African conventions and charters promoting and protecting the rights of women. In many ways, the persistence of harmful widow practices Mathias identifies echoes the persistence of FGM, and as Mathias argues, many of the supporters of these practices were elderly widows themselves. Drawing on the concepts of false consciousness and the patriarchal bargain helps Mathias explain the persistence of elderly widows promoting these harmful social practices. But the Balengu also practice very local residence, marriage residence, which puts widows at significant risk of losing access to land and labor. In addition, Mathias indicates that in marrying women bring into the household spirits from their own lineage and kin groups that may destabilize the household. According to Mathias, death is never natural, and widows are often held accountable to their husband's death. Balengu widow rituals clearly discriminate against women and are thus in opposition to both Cameroonian law and international human rights, but they still persist. And those are questions we need to address. Thank you. And let me turn this over to both the moderators and the rest of the panelists for their comments.
That was great, Richard. Thank you for those really rich, generative comments that I'm sure we'll come back to. Why don't we follow the practice that we established somewhat early on and move through in order, which means that if Pearl would like to respond to some of the comments, Pearl, we invite you to begin.
Did we just lose Pearl?
Did we just lose her? I'm looking for her. It looks like we may have. Oh, okay. Hopefully she'll be able to jump back on. Then in that case, let's move to Sarah Zimmerman. Sarah, would you like to respond to some of the comments that Richard's offered?
Sure, and thanks to Richard and thanks to Emily and Benjamin for organizing this colloquium. It forced me to think about some questions that I hadn't been thinking about in looking at some new materials for, I guess, the next book project. So I think I'll echo Richard in saying that I think you know, several of your 7 points are rather important for my project in terms of thinking about widowhood in urban areas, as well as something that I was initially really interested in is this kind of changing context of wealth and power from the late 18th into the 19th century. On Gorée Island. And I ended up kind of making more of a broader scale argument in which I tried to locate widows within. For those who haven't read the paper yet, it's very different than what I proposed. And actually, you know, in some ways ended up being kind of taking a cue from Emily Burrell's work in terms of thinking about widowhood as a legibility project. And kind of finding out kind of what it means when it appears in the archival record. To Richard's question about legal traditions, this is something that I've actually been really struggling with and need to spend a lot more time reading into. As someone who was a scholar of the 19th and 20th century who was moving into the 18th century, I have become rather confused on Gorée Island about jurisdiction and how and whether legal jurisdictions that emanate from European kingdoms actually make women on Gorée beholden to those laws. And I think this is something that I'll be able to see better, you know, once I get back to Senegal. I had hoped to do that in December. I don't think that's going to happen, but and take a longer look at some of the source material that another panelist in the previous panel, Mathias, looked at. I haven't yet looked at some of those prorate and inheritance records that are in the Z files, and I think that that will be helpful, at least in terms of understanding legal tradition and legal operation on the island itself.
That's great. we can move. We can keep moving. Abbass, would you like to respond? And Pearl is back, so let's maybe Abbass, you can respond, and then we'll move to Pearl. Let's make sure everyone is. Yes, Abbass, you're muted. There you go. Perfect.
Thank you for organizing this, especially you, Emily and Benjamin. And thank you all for helping us now develop this and participating. So regarding my paper, I look into these ambiguities of and changes and dynamics of Islamic law in 19th century and by extension 20th century Mauritania. And so one of the things that I encountered here is that widowhood was contextualized, and this is what I could get from analyzing Islamic documents. It was highly contextualized in various orders of property. So these Saharan scholars, they usually copied older Islamic legal opinions from Morocco, Tunisia, and Algeria, but they used them differently to arrive at different social conclusions. And they were not normative in their answers. We seem to have to get different solutions to the same widowhood case in different times and different situations. So I'll say something about these Islamic scholars. So far, it's a preliminary research, but I focused so far on Al-Ghasri. He was a 18th century and 19th century Saharan scholars based in Walata. In fact, he engages a lot of stuff that were happening in Sudan. He did in 1819, and I am also engaged in other Islamic scholars, such as Sidi Abdullah al-Hajj Ibrahim, who thrived in the middle of Mauritania, in Tagant. And I am engaging with other scholars, such as Ibn al-A'mash, who lived in the 17th century, but still widely copied and used for various presidential legitimacies. So these are basically, in a nutshell, these scholars that I'm working on. And ultimately, I will be extrapolating more than 100 Islamic legal opinion regarding widowhood. Of course, there are many other legal opinions that go beyond widowhood, but are very relevant to it. So that's about basically the social background and whereabouts of these Islamic scholars. Yes, I definitely should look into the dynamics of dowers versus dowry and try to tease it out more carefully. So I thank you for that. And yes, that's for now.
Okay, great. Thank you so much, Abbass. That's really, I'm interested in those sources too as we continue our discussions. Pearl is going to join us. She's having some connectivity issues, but her audio is working. So we're gonna see if we can move forward with the audio comments and response from Pearl. Pearl, you're muted right now, but if you unmute and give it a go, let's see how it works. And if it doesn't, we'll just maybe you can do some chat comments. It looks like you're successfully unmuted, Pearl. We can't hear you, Pearl, if you're speaking. Okay, that's too bad. Pearl, we can't hear you. If you can hear us, I'll respond to you in the chat. Given that, let's see, Mathias, would you like to respond? And I'll work with, oh,
Hello, everyone.
Yeah.
I'm writing to her. Pearl, we cannot
Pearl,
hear
unfortunately,
you.
it's
Okay.
very broken up.
Why don't we do this? Here, I'll mute Pearl's audio.
She's dropped off.
Yeah, okay.
Let's
for
go to
Pearl. Okay,
Mathias.
Mathias.
Thank you very much. Thank you for the comments. Before I respond, I would like to take the opportunity to introduce my research partner, Dr. Ngambok Vitalis,
Great.
who's joined us from Sweden. I think he's a person who pulled me into this and has vast knowledge on this widow practices in the Balingu region in the grass spheres. So I'm going to respond, and I'll also hand over. I hope he will also chip in something. So
Welcome, Vitalis.
So I think the reason why widowhood rites and practices still persist in the grass field despite Christianity and modernity, as you asked, it's because of the fact that Cameroon law, as strong as it is, it's more of declarations, it's hardly enforced, and it ends mostly in the urban areas or in Yaoundé, let me put it in that way. So in the villages, people don't know anything about Cameroon law. What is happening in the villages is mostly customary law, which it's dominated largely by patriarchy. So the Balingu kingdom or village happens to be a highly patriarchal society, such that decisions, customary law is controlled by men. Women are seen as property owned. The moment a woman gets married, she is seen as a property to her husband. And women are also seen as people who can give and take life. And as a result, men have put some of these conditions, leave rate, and associated restrictions that are meant to control the powers of the women. But also at the same time, elderly widows also control significant authority over the younger widows through what they call a test of innocence, such that the moment a husband dies, I mean, the wife is always the first suspect, and she has to go through traditional rituals which are very, very degrading. And sometimes she is left with nothing. She has to go through all these rituals. In some cases, she's sent out of her matrimonial home without anything. But on the contrary, the moment that a woman dies, a husband is rewarded with another wife or even wives. So it's a men's society, it's a men's world. Women don't really have enough power or voice in some of these communities. But the younger widows also feel that submitting to these rituals is also a form of some kind of inclusion for them. Even though they're disempowering themselves or putting themselves in some kind of difficult positions, but they feel that it's a step towards attaining the position of older widows. So at the end of the day, it persists because women are also contributing towards their own suppression, let me put it in that way. But there are exceptions where some women maybe who have the social capital. I mean, they can go extra miles, they can go to courts and defend themselves and maybe have a voice over their husband's inheritance. So it's a situation that it's promoted both by, in spite of the fact that it's a kind of restriction that men are placing on women, but it's also promoted by widows. Because widows, they don't stand in one voice. I think just a couple of years ago, I lost my younger brother, and three of us were compelled to take his wife. So we were asked who among us was going to take the wife. And I mean, if one of us had accepted, then it would have meant that we're also promoting such things. But we resisted and said, no, we can't do this. I don't think that I will mourn a brother by taking over his wife in the name of tradition. So these things are things that should be seen from different angles and not just something that should be attributed to one particular reason that is persisting because of a single reason. It's a multiplicity of factors that contribute to the persistence of widowhood rights and practices in the bilingual region. So I think I will end there and hand over to the senior person in the field so that he can maybe give his own input. Thank you.
Mathias.
Vitalis.
Vitalis, do you want to say something?
Yes, I'm trying to see if Vitalis is unmuted.
Okay, well, Pearl popped in, so let's just hear from Pearl if she wants to come back. Yeah, we still can't hear you properly, unfortunately.
Okay, that's unfortunate. Pearl, I'm just going to mute the sound because it's feedback. But what I've done is Pearl and I are attempting to connect on the comments and over email. Oh, here she goes. Excellent. Okay. Okay. So Richard has written his comments in the chat, and hopefully Pearl will get a chance to respond to them. So we'll have some asynchronous engagement with Pearl in the chat and in email. But so maybe what we should do for the moment is shift to a broader conversation with the group about responding to what we've just heard. Does anyone have any comments they want to add?
Well, I want to talk a little bit about rights, because I think these are things that I've come across a number of times in asylum cases. So I think it'd be useful if we kind of document the sort of spectrum of rights, the types of rights that people are engaged in at the immediate bereavement moments, right? So I had a couple of asylum cases where, for example, one woman had to touch the body of her late husband and then use the liquid that she had washed the body in make for the family. Another case is of a woman being locked in the house with the dead body for 30 days, which I couldn't quite get my head around. And of course, I don't really fully, but all of these things are framed within the context of tradition. But it also brings us back to this division that we're between the urban and rural. I've heard resonating in some of Mathias's comments as well, and Sarah's comments, this idea that there is this we need to somehow think through this this division between urban and rural, and what it means, where law starts and ends, and where custom starts and ends. So those are just some thoughts that I was having.
May I please?
Yes,
yes, please.
To the issue of the urban-rural divide, I really agree with Richard that these are not just clear-cut when we talk about societies that are increasingly urbanizing, because of the degradation of the environment, for example, the deprivation of the countryside from major sources of production. And so these, as I see, for example, in my own native Sudan, it is not as clear-cut as it used to be, to the extent that you see a lot of people, writing opinion pieces about the ruralization of the city, that basically the countryside had been just evacuated. So I don't know, unless if we are dealing with some kind of a historical incident about these divisions. I don't know, just going forward in understanding how diverse and differentiated and unstable a category widowhood is, also as Richard said. I don't know if we are dealing with more current experiences of widowhood, if it would really obtain.
Thank you, Khaira. Other comments or responses? Mathias, did you?
Abbass, yeah.
Oh, Abbass.
Yes, thanks to your papers, I was able to see new venues of basically widowhood, namely this idea of leverage and so forth. What I noted is that leverage is very represented from different angles, from different power situations. It's at least from the documents that I engage. That widowhood, like leverage situations, are represented in patriarchal discursive tone. It's for the protection of the widow, and in fact, sometimes that's the same widow discourse about leverage situations. But it seems that when they are represented in the French document, it's totally different. So what to do about that? Whether to hastily think of the French as more feminist versus Saharan documents, which are obviously. Also, the idea of norm is really something that comes in, because it seems that if you look at it from different centuries, the Islamic norms are they are always produced within this Islamic tradition, but the practices, the norms themselves vary. The social order itself is different. So what I'm trying to say is that Maliki norms don't produce the same practices, even if they sometimes agree, even if it's a total tradition. It seems that in Morocco than in Mauritania, while the same scholars interact, networks of scholarship and dependencies.
You know, Abbass, if you keep your hands still, the sound is better. So just don't do that. Don't talk, move your hands. I want you to tell the readers a little bit about your fatwas, right? Tell them exactly what they are and why it's a useful source for widowhood.
It is useful because, first of all, we see more voices of the widows within them. And this brings back the idea of ignorant widows, because it seems that these widows, they come usually from learned Islamic communities, and they are able to use Islamic texts to their benefit. So we see the questions are framing those questions and the authorities that they are using. And these Islamic opinions, they are not mandatory. They are legal scholars, as different from judges. But they influence the judges because they have more scholarship. And it seems that these widows are using these distant Islamic scholars and sometimes trying to orient their responses for their own benefit. Sometimes they succeed, sometimes they don't.
I think that's the key thing. That's the key intervention there.
That's great. And it also sounds like, just quickly, it sounds like maybe Abbass and Wallace might have some overlapping connections that they might want to talk to each other about. Vitalis, you've been waiting patiently.
Not me.
Vitalis?
Yeah,
We might have, maybe we lost him.
Mathias, do you want to address anything?
yes, but I would like her to maybe repeat the comment she made, please.
I'm sorry, I can't hear any comment by Vitalis.
He's muted. He's muted.
Let's see if I can.
Okay. Are there other comments, other questions?
I think Vitalis is on now.
Ah,
Yes, I was going to say that some of the issues around widowhood have to do with this whole idea of legal pluralism, in which at one time tradition is invoked, on the other side, the law is invoked. And then tradition usually refers to this idea of the law of witchcraft, which is also, there's also the issue of the modernity of witchcraft, which means that even when a woman decides to go to court, she's apprehensive of what will happen to her when she wins the court case. It may take years and years, and without any legal aid or resources, her chances of winning even the case are slim. And then the court also is also very complicit. The court sometimes refers to what I may call the modernity of tradition by resorting to tradition and customary law. So there are actually multiple layers of legal and traditional issues around women's unwillingness to fight back, or issues that constrain their freedom when they fight for their rights as widows.
That's an excellent and important insight. And again, it reminds me of Burying SM, for those of us who've read the book Burying SM, because that book really sheds light on the importance of understanding legal pluralism within social contexts. And I think that Vitalis is right. We have to keep thinking about these multi-layered legal contexts. Pearl has responded in text to the comments that Richard had for her, namely, Richard had said, he suggested that Pearl and Adubi may also want to probe the constraints that prevail when Christian communities help widowed congregants. To what extent does such help constrain the widow's life choices, including whether or not to leave the Christian community? And Pearl responds saying, yes, I have probed into that area. I think it's a laudable idea to research. When I looked at it, at the challenges and the consequences that widows went through and the coping strategies used, this is something I'll continue to pursue. So she acknowledges that and thinks that it's important. Okay. Other comments?
Emily, I just put
oh yes, I see.
the trials of Mrs. K,
Yes.
Seeking Justice in a World of Witches, by Adam Ashford, talking also about the issue that Mathias and his colleague were talking about in the boundaries of the customary law and the modern law in the case of Malawi, which is very interesting. So,
yeah.
Thank you.
It makes me think of that. I don't know how many of you have seen the film I'm Not a Witch.
Yes.
Which came out of Malawi last year or the year before. Malawi, Zambia production. We just reviewed it actually. Katie Luongo just reviewed it in the Journal of in the African Studies Review. It features a really interesting community of widows who are tied to the land. They're basically moved around. Their labor is acquired by some wealthy local politicians, and they're moved around on the back of a truck to various lands where they work agriculturally. And they're tied. Now, of course, the film itself is a is a fictionalized representation. So there are some artistic flourishes, such as the fact that all these women have very large ropes tied to their legs, meaning they can't run away. They're all tied back to the truck. But they work on the, so there's some liberties, artistic liberties taken with the illustration. But the representation is that this is a politician who is doing good by looking after widows who have been abandoned and who would otherwise be homeless and destitute. And he has pulled them all together, and the way he provides for them is to shepherd them around to various fields where they work, making money for him in order to then also survive and sustain themselves. Kate?
I just wanted to ask a question to Pearl. I know she might not be able to answer me, but one thing I was kind of intrigued about is that I had understood that in Ghana, although it's possible to contract a marriage under the marriage ordinance, a lot of people who are Christians don't actually contract their marriages under the ordinance. So they're basically having a customary law marriage, which is then blessed in church. And this seems, I mean, Stefan Misha wrote a bit about this in the 90s, that this kind of created legal ambiguities for widows and widowers, because sometimes people would say that, oh, well, if you're a church member and you've had your marriage blessed in church, when you die, your will should follow the recommendations of the church. And some churches, like the Presbyterians, actually kind of set rules for what the inheritance kind of policies should be for their members. But then, of course, technically this is a customary law marriage. So then maybe if you go to court as a customary law widow, what's actually going to be applied to you now would be the intestate succession law. Before the intestate succession law, it would have been customary law. And because so few cases do actually get to court, what's sort of intriguing me is how far the Christian churches can actually put pressure on members to not to do things like push widows out of matrimonial homes. Because obviously in some contexts, these practices are still happening, even though the intestate succession law specifically criminalizes the driving out of a widow from a home. So I'm just kind of intrigued about where the marriages of your study participants kind of sat, and whether you saw any of these sort of struggles in individual cases between what relatives saying, well, this is our custom, we need to do it this way, and church members saying, no, their husband was a church member and therefore the inheritance should be dealt with this way.
You know, I think Pearl just dropped off the call again, unfortunately.
Yeah,
we lost her because it's hard getting the bandwidth at this time of the evening, particularly in Ghana, right? This is the peak time in Nigeria and Ghana. So unfortunately, we've run into that problem. But I think it would be fascinating if we could put together some of these church rules about inheritance from different countries, because you think you put your finger on something, Kate, that there are bound to be particularly well positioned churches in different countries, maybe, I don't know, maybe even the Kimbanguist church, or maybe some of these larger African churches have documents pertaining to these types of issues, which would be worthy of scrutiny. But we've come to the end of our session. So we're going to break for a few minutes. And then we're going to resume. And the final panel is going to be the discussant for that is Casey Golomsky, who's an anthropologist who works in South Africa. And although he didn't supply a paper to us, he's going to talk about his current research project on Black and white widows in South Africa, and the relationships that Black nurses have with white elderly people in nursing homes. Although there are only 2 papers on the panel as it currently is, Casey will just be discussing for that, but he'll also talk a little bit about his own work. So let's just pause for the moment and thank everybody again. Thank Mathias Vitalis. Thank you for joining us from Sweden. I think it's great that you're able to join us, and we'll be resuming in about 5 minutes.
Thank you, everyone. Benjamin, are you still there? Okay.